Now, 8 of the provinces were very much against, as you recall, the so-called Gang of 8 were against the entrenchment of a charter because they believed they had grown up politically and otherwise on the principle of the supremacy of Parliament. And they did not accept the idea or the principle that judges should be able to declare unconstitutional acts of Parliament or parts of acts of legislation that have been created by elected judges and
appointed judges.
Elected parliamentarians should not be able to have their legislation changed by unelected judges. And so this became a very major controversy, and this is where the issue of the notwithstanding clause that came up in order to reach a compromise where it said, well, notwithstanding a section of the charter, a Parliament could overrule a judicial decision, but only for 5 years. And the other major item of debate was the amending formula. And it had been and of course the battle in the Supreme Court of Canada had a lot to do with that, and I argued the case on behalf of the government of Ontario. And it was the provinces who said, well, the federal government can't amend the Constitution without the consent of the provinces. It was assumed that they met every province, and which would have been impossible. But what we finally ended up with was simply an amending formula that said that 7 of the 10 provinces representing 50% of the public, and then again there's a lot of background as to the role of convention in constitutional making and the decision that said that, well, the unilateral initiative on behalf of the federal government was strictly legal constitutionally, but it offended a convention, a constitutional convention. Well, up until that time, constitutional conventions were not recognized as legal instruments. And Chief Justice Laskin, in a very strongly worded dissent, pointed that out. But so there is a lot of interesting history to me, of course, because I was there and getting old now. And cling to some of these memories, but it was several major points that were debated by the political leaders rather than the nitty-gritty of the drafting.
So many authors and a very long genesis.
That's right.
That sets the
I'm
stage.
sorry if I went into too much detail. But,
no, that's fine.
But these issues can get a little complicated.
One of the most cherished provisions of the Charter is Section 15, which sets out the equality rights to which everybody in Canada is entitled. How did you and your colleagues decide which to enshrine in the Constitution and which not to include?
Well, again, most of the drafting was done by the parliamentary committee, and because the politicians, political leaders did not get into that nitty-gritty or it would have taken years. Now, I think it was just sort of assumed what would be there, perhaps from the 1971 charter, but I think that the principal gap was the failure to include a prohibition against discrimination on the basis of sexual orientation. And that was presented to the parliamentary committee, and it was not included. But in about 1970, well, no, maybe it was about 1995, the Supreme Court of Canada decided to give a very broad interpretation to the equality section and read in sexual orientation as an analogous subject for protection. And so, much to the annoyance of Ralph Klein in Alberta, they amended unilaterally. The court amended the Alberta Human Rights Code to say that includes sexual orientation as a ground of prohibition.
Was it?
We did the same thing in our same-sex marriage case of Halpern. That's the Ontario Court of Appeal. When I was Chief Justice, we wrote the decision. I was the president of that court that created the legality of same-sex marriage. And basically, we kind of amended well, we didn't amend the legislation. What we really amended was the common law, but that's another subject for a more boring discussion.
But was it the thinking of the politicians at the time that the Charter would be a living document that would evolve as society thought differently about equality rights?
Absolutely. Absolutely. And I think the next Chief Justice, Brian Dixon, talked about the growing tree doctrine. And this is so much different than the Justices Scalia and company on the Supreme Court of the United States who talk, they have this originalist approach and say, well, no, we're going to, and we've got to decide what the drafters of the Constitution meant. And they rejected the growing tree doctrine in our own Supreme Court, which makes, of course, a whole lot more sense.
Do you recall any discussion of racial equality at the time?
Well, it was assumed that racial equality, that the Section 15 prohibit discrimination on the basis of race. I mean, that was right in the original draft. That did not have to be read in by any of the courts later.
Okay. In the last 7 or 8 years, there's been a chorus of complaints about judicial activism, and they're usually directed at charter judgments. Did you and your colleagues foresee this, and do you believe the courts have overstepped their role defining rather than interpreting law?
Well, as having served as a Chief Justice for 16 years, I'd be reluctant to be critical of the judges, nor should I believe that they be criticized. I want to emphasize the point that I made earlier, that the elected parliamentarians, they handed over this responsibility to the judges. We did not, no judge ever suggested it or requested it. But we realized, speaking as a politician of the day, that we were embarking on uncharted waters, and we could not predict with any certainty as to how the courts would react to this important new responsibility. But having practiced in the courts for many years before I entered politics, I had a fundamental respect for the courts with respect to behaving responsibly. And there'll always be criticism of judicial activism, but I don't think it's justified. Some judges make mistakes, and that's it's always been that way. But I think we've created a very good balance between the elected legislatures and the courts. And I think there is a degree of mutual respect, and certainly judges don't want to be thought to be high-handed in interpreting the Charter. But it also should be emphasized, and I know we're running out of time, but it should be emphasized that the Charter of Rights is for the minority, not for the majority. The Charter of Rights is fundamentally a document to protect minorities, and the majority of Parliament are there to protect the majorities. So that's the fundamental difference.
Thank you very much, and I'm afraid we have to wrap
No,
this
I
segment
understand
of the
that.
program up.
Nice to see you as always, Carol. Thank you.